Okay. Barbara's still not here yet. I know she's
She
going to talk
was
about
here
legal
and then she
stuff.
walked away.
Yeah. She said
I
she's going
guess
to be
our
on tomorrow.
conversation was not interesting enough for her.
Well, I don't know. This topic always reminds me of Shakespeare's Henry VI, when
Hello, the lawyers.
the one he says, first kill all the
There
lawyers.
we go.
Um,
No, 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 please, 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 please. I have good things to do yet in my life. Don't bother.
okay. All right, Barbara, I am going to go ahead and turn it over to you.
Okay, just let me see if I can get my, here we go.
By the way, if it runs a little long, I actually set these up to record for an hour and a half. So,
It'll be less than an hour and a half. Let's just hope that this appears on here. Uh,
by the way, I was just kidding about the exam.
I thought that was a great come on. However, I'm not finding
Did you want to
what I'm looking
share a
for.
screen?
No, I'm not even finding, let's see. It's on my other machine. The worst that'll happen is if you take 2 seconds, another 2 seconds, I'll get, hmm. Okay, it's here. Open. Um, okay, now we have to go to share screen.
Okay.
Where is your shared screen?
I just gave you permission.
But I have to push
You
something
have to hit
here?
down there where it says share.
Just a minute, it's not doing its thing.
It's at the bottom.
Now just hang on 1 second.
If you have
Okay.
it on full screen, you may not be able to see it at the bottom.
Yeah, I know. But it won't. There it is. It's low. Oh, okay. Hmm. We may have to go to Plan B. Just a second.
Okay.
There you are. Okay, there's share screen. Okay, now, but there, chaos in the courts.
There you
Coming
go.
up. There we go.
And I will.
Okay, are you seeing this? Okay.
Yep.
Was
Okay. Great. So we're going to talk about chaos in the courts, which is read along with today's column. It's not the same thing. I will go farther, deeper, and I will bring other cases in besides the Zantac, which I've talked about, but I want to discuss a little bit more about Zantac. Let me just do a quick review of how we got here in the courts. In the 1990s, and there's Jack Book, in the 80s and 90s, there was an implosion of a witch hunt against various products. The Dalcon Shield is one of them. The silicone breast implants was another. Jack's book does a marvelous job of putting everything in context and documenting what led to what. Jack, do you want to add anything to that?
No, no. Well,
Okay.
it was an outgrowth of a writing project I did for amusement after I retired. I went back to get a degree in history and picked regulatory history as my focus. So it was easy to, do a little bit of a history of how the FDA got its power, and then I went into what we had to live through in the 90s. So if anyone is interested in the past, that's one. But I think your focus is on more recent misadventures.
My focus is on more recent misadventures, but how we got here. It's important to know how we got here. It's, it's not just, you got to know where you're going. I think you got to know where you came from. And we came from that. There were other books. Peter Huber wrote, what was his book? Well, Steve Muller wrote Junk Science Judo, but he's now gone to the extreme. Peter Huber wrote Science in the Courts. And that led to the legislation or the act that we now know as the Daubert case. However, I do need to call attention that as much as there was a witch hunt against various products, the Dalcon Shield, the silicone breast implant, some Bendectin, which is what triggered the Daubert case, there were some legitimately bad products out there. And the reason I mention that is because we'll see that that's happening today. And the bad products, of course, one rotten apple spoils the bunch. One really bad product was an arthritis drug called MER-29, and it was manufactured by Merrill Richardson, which was a preceder in interest to some of the drug companies now. And the drug companies knew, there's no question about it, that the drug caused cataracts and some kinds of irreversible blindness. They knew. What they did was they calculated that the amount of suits or the number of suits or the payout would so far be diminished from how much money they could make that they just squirreled aside a war chest to pay for the litigation that they knew would come. And this was discovered by a really good plaintiff's attorney named Paul Reingold, who is not one of your avaricious. He was this really low-keyed, mild-mannered guy. And that's what they did. They knowingly marketed a defective product. And of course, they went bankrupt and things went bad. But that kind of thing lays the basis for some of the rhetoric, the inflammatory rhetoric that the lawyers use today. So, but it's important to know that there were and are some really bad products out there. And our job is to call out the phony baloney claims, and there are lots of them, and they cost a lot of money. And the whole perspective of the plaintiff's bar is to force settlement. They want mass settlement. They just want to squeeze the manufacturers and let's get a bunch of stuff. But we have to keep our eyes out for the things that aren't so great. Okay, so this is what's on off the table this year as opposed to last year. It's a graph I put up last year added. So the dark blue ones are pretty
Not
much—
seeing the graph yet.
We're not seeing any graphs,
Not
Barbara.
seeing any graphs. We just
It's
see
not a
the,
graph.
Open a PowerPoint.
It's not a graph, sorry, it's a picture.
no, it's
We're
not
not
up yet.
seeing anything. All we're seeing is a
What's on or off the table? You're not seeing that?
It says, all it says is it's got the PowerPoint icon and it says chaos in the courts, but it has not yet been opened.
it's not opened.
Oh, dear me, what's going on here?
Is it open on your screen?
Yeah,
No, not yet.
Do you have two screens?
hmm. Can you see it now?
Nope.
No.
Do you see this now? You see any pictures?
All we see is what we had before, which is just the chaos in the courts, but the little
It's in
You're not
an open
getting
file.
the pictures. Okay, what I'm gonna have to do, take 2 minutes and switch machines because and get it on the other machine. So
okay, do you want me to pause?
yes, please.
Sure you don't.
Do you see that?
Now we see chaos in the courts 1 year later.
Yay! Okay, you seeing it?
Yep.
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 You
Good.
seeing
Yep.
that one?
Silicon
Okay.
Tribe.
Yeah, yeah.
Okay. All right, we got it. Okay, so there's what's on or off the table. So the dark blue boxes were on last year and they did not materialize. They're on the back burner. The ones that are pretty heated up are the ones in purple, like last year, Zantac, Roundup, and Talc. Why they haven't gone away, we'll talk about it. The ones that are getting a life of their own are the barred hernia mesh cases, but those aren't so big. The ones that will probably skyrocket are the Ozempic cases. And then we have the PFAS cases, or what's called the AAS cases. And these are what's commonly called, or what's referred to as the forever chemical. Whether it's a forever chemical or not, I don't know. But these cases are pending by firefighters by polluting the water. There may be some cases about benzene in sunscreen and acne preparations. And then, of course, there's the Gilead case, which has issues that transcend the toxic tort issues. So I will try and devote a whole article to that. Maybe, Tom, if we want to do another Salk talk about it, but that has broader, more troubling issues that go to the very heart of litigation. Okay, then there's the shaken baby cases, nothing's happened. And then the alkaline water cases, which are really important, although they will not be a big deal because not that many people were affected by them, but they need to be done. Okay, so before Daubert, there was Fry. Fry came out in 1923. It's not a Supreme Court case. It was decided by the appellate court in Washington, D.C. In my opinion, it was a political case because the judges did not want to rule on this newfangled scientific evidence that was actually designed by a guy named Marston, who, by the way, was the originator of Wonder Woman comics. He was a psychologist who pretended to know a lot about everything. And he had a prototype of a lie detector test. And he wanted to use his lie detector test to prove that the confession that Mr. Fry gave was a phony confession. And the court said that this lie detector just wasn't scientific enough, hadn't been used enough to obtain a certain degree of credence, and created this general acceptance in the scientific community rule. What's interesting is very few people ever deal with what did the judges do before 1923? There wasn't any rule. And basically that's because before 1923, a lot of the judges studied science. Many of them had gone to court, had gone to college, they had taken natural philosophy. They were not science averse, and so they just decided on the science. One of the earliest cases I could find was in 1896 about whether X-rays can make diagnoses or determine whether a bone is broken 6 months, literally, after Rankin discovered X-rays. And the judge had no problem understanding it whatsoever. So the judges understood things. Fry came, they wanted a way out, and we had general acceptance. By 1993, which is 70 years later, the courts were just not studying science, didn't know what they were doing, letting science in right, left, and center, and saying, let the jury sort it out. And of course, the jury couldn't sort it out. Now, juries can do this, but they have to be taught by the lawyers. And the lawyers don't want to learn science. As one young lawyer when I was practicing under my traineeship said, if I wanted to learn science, I would have been a doctor. Well, if you don't understand the science yourself, there is no way you are going to convince a jury. And you are seeing now more lawyers learn science. Most of them go into IP work, intellectual property work, because it's much more lucrative, but some are going into this. And I actually saw one video of a woman lawyer in a Roundup case, and she was doing a brilliant job explaining the science, and they happened to have won that case. So the juries can get it, but it's the responsibility of the lawyers to teach it. Now, these are the 5 Daubert criteria. Can the theory be tested? The second one is really interesting. Have the test results been the subject of publication and peer review? And we know lately that the publication and peer review process is incredibly suspect. And I see Jack nodding down. It's suspect. There are, I think it's in the thousands now, of papers that have been recalled or recanted. There is a nonprofit that pays attention to vetting these materials. And I'm not even talking about the plagiarism part, but there has been made up science. Now, there has always been made up science ever since the 1800s. And I think it was John Haeckel made up his evolutionary pictures, but now it's all over the place. And with AI, it's sure to get worse because a lot of the pictures that are used, especially in the genetic area, can be created. Again, they're developing software to deal with it. The problem is that where once publication and peer review was held to be the sine qua non, the arbiter, we don't have trustworthy peer review today. Now, many of the journals require you to put a disclaimer of financial conflict of interest. And I've seen so much playing around with that you really have to be very careful. A lot of the articles on RFK Jr.'s website are paid for, are put in journals that are supported by the quote unquote anti-vax industry. I mean, and it says so in tiny print, or you've got to look someplace else, but you've got to really look at it. There's one case where I discussed on a recent podcast with Cameron and Chuck about a challenge study where certain volunteers were injected with COVID, ostensibly to detect the immune mechanism. And then somehow along the way, they did a study of, does COVID impact on cognition and recall and memory? And that study was written by an offshoot of the group that got clearance to do the study. And with the exception of one person who was in both, most of the people in that second study were proprietors in a for-profit company that sells memory development techniques to the government and other people. So there's a lot of playing around here, and it just takes away another rubric to vet the impartiality of the science. So care is very important. Whether, and maybe this is an article, right, whether we delete that standard from the Dalbert test is something we need to consider. There's been a lot of question as to whether Dalbert really made a difference. I actually spoke personally with, my husband was there and a friend of ours, to Judge Rehnquist, who signed on to the opinions, and he said, I don't know what we're asking judges to do. I couldn't do it. So he was not particularly optimistic. But if you look at this graph starts in 1980, and the green box, up where the green box is 1993, that's Dalbert. And if you see the top line, the issue of the reliability of the science was decreasing. Nobody was even raising it. Not where it was, where it was raised. Let me see. Where it was raised, you'll see that it goes down, but found unreliable. It wasn't really found unreliable in many cases. It's where it was raised a little bit between 91 and 93, and that's when, Jack, when did you write your book? When did you publish your book?
Turn of the century. I carry the story up to the 1998 with the Institute of Medicine study that really put the thing, took the issue off the table.
So by 1990, the issue was getting notoriety, and judges, and you could see a little sensitivity, but basically from 1980 to 1990, judges weren't really paying attention to science. Now, 1993, where that line is when Dalbert happens. And as you see, right after Dalbert, the reliability issue was addressed, more people raised it, and more cases, more evidence was found unreliable. So it looks like Dalbert made a difference, and everybody's saying Dalbert made a difference, and Dalbert was in favor of the defendants. Now, because if the evidence was found unreliable, more often than not, it was the defendants. So what happens in 1997? We go right back where we started. So the situation now is Dalbert did not make much of a difference. What it did do, though, is, and what I'm seeing happening now is many judges are paying more attention to the science. where before they just threw it and said, let the jury handle it. Now they're looking at it. And there are some really good examples of judges really delving into the science. The best, I have to say, was not an American judge. It was an Australian judge named Judge Lee in a Roundup case. It was 300 pages, which I suffered through every page. And he went through every single possible way, the epidemiology, the toxicology, the animal studies, and he concluded there's inconsistency there, but on the whole, I don't see any evidence that Roundup causes cancer. You did not see that case even mentioned in the United States. It's a recent case, and nobody wants to pay attention to it. So, but judges are paying more attention. Here is a more accurate graph, but as you can see, the reliability and the exclusion today is a little bit less than 1988. That's the bottom line, the green line. We're letting in we're letting in more evidence than we used to. That's not so great. Okay, so let's start with Zantac. Zantac was created in about 1980 by GlaxoSmithKline. And everything is going along just fine until about 1919, when a company called Valisure brought a citizen suit. Now, we'll talk about Valisure in a second. It has, maybe corporate types know these companies, Alicorp and Connecticut Innovations. Its clients, it claims, are the U.S. Air Force. They denied it, I think, after a while, and Kaiser Permanente. And they brought a citizen suit saying Zantac, which is basically a chemical called ranitidine, is okay, but over time, Zantac degrades into a probable carcinogen called NDMA, which is ubiquitous. And they said that the amount of NDMA that was found is off the charts. Well, the FDA does its own test, and they find in some cases a little bit of excess, not a huge amount, but in the abundance of caution, they withdrew it, recalled it, and all of the manufacturers of Zantac recalled their products. Meanwhile, the plaintiff's lawyers, there's one of them, is getting their hands on it. Let me just. Okay, so Valisure, who is Valisure? Valisure is a company that was started by a guy named David Light. And how do they make their money? They make their money mainly by testifying in these recall cases. They're expert witnesses. They find a product they don't like. They bring a citizen's case to the FDA. The FDA recalls the product, and they testify. Now, this is a quote from an article. David Light, Valisure CEO, ran afoul of the law while at Yale University when police discovered an illegal arsenal of weapons and explosives, leading to a 1-year prison sentence. The lab said it scored a drug testing contract with the Department of Defense, although it seems that that's been rejected. Anyway, Valisure goes around testing. It's when its first, which was Zantac, it is now looking into benzoyl peroxide in suntan lotion and hairspray and all sorts of stuff. Okay, now this is a really interesting graph. So in September 2019, the FDA responded to research and they found a little bit of extra Zantac, which showed contamination worsening. Look at the numbers, look at the trajectory of complaints. Nothing, this is the same medication, nothing until 2009, until 2020. Nothing until the recall. Nobody complained about anything. Then all of a sudden, there was a recall and everybody's complaining. Now, it would be interesting to see if there's a power of suggestion here, or if people just decided, uh-oh, let me look. But nothing happened until the recall, except the law schools, the lawsuits. The evidence repeatedly has shown that ranitidine itself does not cause cancer. I don't think there's anybody that says that it causes cancer. The issue is, does it does the breakdown product cause cancer? Now, the breakdown product NDMA is ubiquitous, it's every place. But in the beginning, GlaxoSmithKline tried most of the cases. 2 years ago, Judge Rosenberg in Florida reviewed the proposed testimony of 10 expert witnesses and found all of them not to rise to the level of reliability that is expected in court. There have been 16 epidemiological studies. There's no consistent or reliable evidence. So she throws out 50,000 cases. Even in the cases, there are 3 cases in Illinois where the judges let in the science. The juries either found no liability on behalf of GSK, or it ended in a hung jury, which is to the plaintiff's bar the kiss of death, because it means they've just wasted a couple of weeks of trial. This is where the big divide happens. A couple of months ago, 80,000 state court cases presented themselves before a state court judge in Delaware. Delaware also follows the Daubert standard, but Judge Medinilla, and I read her opinion line by line, she goes through each one of them and she says, oh, this is a jury question. This is a jury question. This is a jury question. She does not want to get into the science whatsoever. She wants to throw it all to the jury. Now, that's not what Daubert's about. And she cites to a Ninth Circuit case saying, we have a relaxed standard of Daubert following the Ninth Circuit. And the Ninth Circuit says, we do not have a relaxed standard. I mean, she just misstates the Ninth Circuit to make herself look good. Daubert is Daubert. And Daubert requires the judges to act as gatekeeper. That means before the case, the evidence goes to the jury, the judge is supposed to look at it, and she just basically looks at every single thing before her, she says is a jury question. This is right after Judge Rosenberg says it's all bad. Judge Medinilla says it's a jury. The kicker is that the procedure in Delaware state courts is akin to federal courts on a procedural basis. In state courts, generally, if a judge makes a mistake or you don't like a judge, you can appeal it immediately. In federal court, you can't appeal the decision until the case is over, on the hopes that you'll get the verdict you want. Why bother the court? Unless the issue is so pressing and will apply to across the board or is so important. If you want to get what's called an interlocutory or intermediate appeal, what you have to do is you have to get permission from the judge who decided against you. And then you have to get permission from the appellate court before they'll even look at the case. And in this case, that was gotten. Judge Medinilla certified it for appeal, and the Court of Appeal said, okay, we'll hear it. And that case is scheduled for trial for a Daubert hearing on December 11th. And on October 8th, a new case begins in California. It's a bladder cancer case, and the plaintiff's bar says, we need a win. I mean, on their website, we need a win, we need a win. This is the strongest evidence we have. Well, if this is the strongest evidence, my question is, does that mean that the other evidence wasn't strong? Anyway, whoops. And this is where I don't get it. On October 9th, GlaxoSmithKline settled the remaining 83,000 cases for $2 billion.
Terrible.
If anybody wants to sign in and explain this to me, I'm open. Now, it is true it would cost a lot of money to try the cases. And there were some estimates that the value of the cases, if they lost them all, was $3 billion. Okay. If I were Judge Rosenberg, would I say to myself, did I goof? Why are these people settling? Yes, they're not admitting liability. Okay, they're not admitting, that's true, they're not admitting. The Court of Appeals in Delaware, who's now going to hear the case, and it's not against GSK, the cases in Delaware against the other three manufacturers, Bellinger, Pfizer, and Sanofi. Will this influence the way the Delaware court approaches the case? It shouldn't, but we don't live boxed up. Now, my sense of why they settled it is, in March, good old Valisher began what's called a whistleblower suit. And the whistleblower suit alleges that a company defrauded the government by making false claims. And they come right out and say, we're not saying this drug is dangerous. What we're saying is you represent Zantac is healthy, and it's not. And in the course of this very long complaint, they have a bunch of really scurrilous allegations, like GSK hid data. These are just allegations. They are not pretty. They have no legal weight. Whether they're eventually proven or not is another question. A recent case, as you saw today, said that these whistleblower cases should be totally dismantled and we shouldn't let them. The government and the 29 cents on whose behalf Valisher is bringing the case declined to sign in with them. In other words, they're given a chance to take over the case or to work with Valisher. Government wants nothing to do with it. I mean, they'll get a payoff, but they're not involved. This is Valisher on its own, raising a whole bunch of allegations, saying that the NDMA is terrible. Now, just to bring to your attention what Valisher has done, when they initially said in their citizen suit back in 2019 that Zantac degrades, they said it degrades at heat. And the heat to which they subjected it to was 277 degrees Fahrenheit, which is the temperature of Mars, not the temperature of the human body. Then they decided, okay, how else can we switch it? And then they poured salt in it, because salt apparently makes it bad. And they put so much salt in the solution that if a human being ingested that amount of salt, they would die from the sodium poisoning. So they basically tortured and contorted the samples to get their extreme results. And they're not realistic results. And Judge Rosenberg realized this, and she tossed it. Again, they make these absurd allegations in this whistleblower suit. And one of the things that they did is, and this to me is like, they showed pictures of degradation under these extreme conditions, but a picture is worth 1,000 words. And you look at these pictures and you say, yuck. And was GlaxoSmithKline scared that this complaint would make the rounds? I don't know. As I said, it's just a complaint. It has no legal value. They are not claiming any causal connection. All this is a defrauded case that the government paid out Medicare, Medicaid, VA benefits for a drug that they thought was effective, and the drug is not effective, although there's no indication. The drug is certainly effective. Whether it could become adulterated under extreme conditions, nobody's ever proven it. And the bottom line that they say is Glaxo knew about, they had evidence, and they should have known to test it. That's a negligence claim. That's not a false claim. That doesn't fit under a false claim. Would it fall under a negligence claim? At some point in the line, it could. Would it sustain a key time case, which is what a whistleblower case is? I doubt it. But meanwhile, as soon as the case got unsealed, or shortly afterwards, the case was unsealed at the end of May, they settled the case. And I personally am very concerned that their mass settlement, which gives Valisher $70 million to finance their other foraging, will have a negative impact on the Delaware court. December 11th is marked on my calendar. I'll watch what the court will do, and I'll report and I'll let you know. But I was disturbed about it. I was disturbed why they settled then, why they didn't wait till after December 11th. Now, I am not a corporate person. They are concerned about their stocks, which weren't doing so great the day after the settlement. Apparently, the stock went up, although in their third quarter, their stocks went down, which was in some way influenced by the vaccines. I have nothing to say about that. And of course, the pharmaceutical companies have dual obligations, turning out good products and satisfying their investors. But that's where Zantac is, and I'm very concerned. Okay. Moving on to the talcum powder cases. Let me call your attention to the fact that the talcum powder cases fall into two categories: the mesothelioma cases and the ovarian cases. The mesothelioma is cancer to the lining of either the lung or the abdomen. Ovarian cancer, you know. There are 62,000 plaintiffs in all 46 cases, which makes it a very lucrative case for the plaintiffs' bar, and they really want to win on this. They are getting, there was one recent payment of $260 million in Oregon. I'm going to tell you what happens. It's not the end of that case. And there was a recent study that says that it can prove ovarian cancer. The bankruptcy settlements that you're hearing pertain only to the ovarian cancer cases. The mesothelioma cases are not caused by that. The mesothelioma cases, if they are caused, would be caused by breathing in the dust. Now, keep in mind, it's not the talcum powder itself that the claim is made. The claim is made that the talcum powder is contaminated by an asbestos-related contaminant, probably tremolite, which means the amount is minuscule. And as we all know, dose makes the poison. But you say mesothelioma, and it's a pathognomonic diagnosis because that's the way Irving Selikoff set it up. And so it's pretty difficult to get out of it other than saying somebody else has made me do it. Now, interestingly enough, there was another recent mesothelioma case, but in September, the Oregon judge overturned the first one. So those cases are still somewhat in flux. The ovarian cancer cases will probably get settled. Whether the mesothelioma cases continue to have a life of its own, I don't know. But here's another questionable. This is the most recent case, $15 million last week, or 2 weeks ago. He claimed he got mesothelioma from breathing his child's art supplies, his child's use of. I'm wondering here whether the medical evidence sustains it, because the latency period for mesothelioma is an average of 50 years, and these people are too young to have mesothelioma. But I don't know if the lawyers who are handling this have the experience with the old mesothelioma cases to have the body of knowledge to know that you need a long latency, and they see the word and everybody just folds. The thing that's really, this is a study saying that genital use was possibly associated with ovarian cancer, but neither breast or uterine cancer were, and that might validate their settlement. So let me talk about Jacqueline Moline for a second, and another question of corporate decision-making. Jacqueline Moline is a plaintiff's lawyer. She makes millions of dollars testifying for plaintiffs. She's gotten thrown out of court. She is, I have to be careful what I would say, but let me think things that Tom would not let me say. How's that? Okay, so you understand what I'm thinking about Jacqueline Moline. The problem is she recently wrote, and she's been thrown out of many cases. She has not been allowed to testify because she's clearly a plaintiff's expert. She's made millions of dollars testifying. Many courts won't let her testify. She recently wrote an article published in a medical journal, saying that in all of her patients, it was a cohort of 75 patients, all of them had mesothelioma, and all of them were exposed to asbestos. Now, whether she suggested to them that they were exposed to asbestos, like her boss, Irving Selikoff, used to do, and I heard him, this is personal testimony, I heard Irving Selikoff say, every person who has mesothelioma has been exposed to asbestos, except for one person. And over 2 weeks, I kept saying, when were you exposed? When were you exposed? Not hours of suggested. And finally, at the end of 2 weeks, and this is a long time ago, she goes, oh, yes, it was in my hairdryer. I mean, he planted this in their head to get this, oh, yeah, and you have to have it someplace. Well, Jacqueline Motlin suggested this to her patients, and all of her 75 patients, or 33 patients, I don't remember, said they were exposed to asbestos. And the conclusion was, I urge all doctors who have patients with mesothelioma to ask if they've been exposed to talc, which is not an unreasonable suggestion. She doesn't come out saying mesothelioma is caused by talc or talc has asbestos. She's just suggesting that this is included in the history. And J&J brought a lawsuit against her for libel. And that decision just came down, if I can find it, and they libel against the property. As to why they did that, I don't have a clue. All they're doing, here it is. All they're doing is making a big deal over it. Here's what she writes. Exposure to asbestos contaminated talcum powders can cause mesothelioma. Clinicians should have listed a history of talcum powder usage in all patients presenting with mesothelioma. Okay, doesn't seem to be so terrible. And here, if you can see, this just came down a couple of weeks ago. J&J lawsuit against scientists over cancer research dismissed. So they're making a big deal over a woman whose testimony has been rejected in many courts. They're giving it a life of its own. I think they might have been better off just attacking the research and saying it's speculation, and a good argument can be made that it's speculation. Okay, round up. As I told you, Judge Lee in Australia just went through every single roundup possibility and said there's no connection. There are 54 cases remaining in an MDL and 4,000 remaining in the States, and another 4,000 claims in California. And the latest Philadelphia win, they found that the product was defective, but that Monsanto failed to warn. Even though they concluded that the exposure was not causal to the plaintiff's non-Hodgkin's mesothelioma. Now, whether that will be enough to sustain a verdict, I don't know, because legally speaking, the allegations of wrongdoing have to cause the harm. So if the defendant failed to warn and the plaintiff could say, had I known, I would not have used it, then the defendant is liable. But in this case, the failure to warn did not cause the harm. So whether that case will stand is an interesting question. I doubt it. The interesting thing is, as the defense lawyers are getting more significant in how to present the evidence, they are doing a lot better. They've had Monsanto won 15 favorable cases out of 22. The earlier cases were the ones that they were lost. That's a pretty good win-loss record, especially since that I watched some of the earlier cases. The plaintiff's experts, just through statistics, right, left, and center, unless you know statistics really well, it would be hard to attack them. As the defense lawyers got more and more acclimated, they did better. The other problem with the earlier cases is that the Monsanto did not concentrate so much on the causation, but on a legal argument that they were not required to warn. And it's an innovative legal argument. In pharmaceutical cases, you have something called the preemption doctrine. The preemption doctrine basically says we want to encourage pharmaceuticals So we will put the FDA in charge of monitoring how safe the drug is. And in most cases, you cannot sue the drug manufacturer. There are obviously exceptions. And what Monsanto Bayer tried to do here is they tried to say, under the Insecticide Act, under FIFRA, EPA is charged with monitoring the chemicals, and because EPA improved it, we do not have to warn. The difference is in the federal preemption doctrine, there's a long, it says so in the legislative history, there's a long history as to why there's no lawsuit against a company, why and it's called the preemption doctrine, everybody recognizes it, and there's no similar long history for the EPA in FIFRA. And in the beginning, rather than concentrating on causation, Monsanto certainly concentrated on the failure to warn. Recently, they won a case on it in the Third Circuit, and a Massachusetts case just followed suit and said that they're following the Third Circuit. Since there are two other circuits that are opposed to this, we will see the case go to the Supreme Court. And that's what Monsanto Bayer wanted. They wanted that issue to reach the Supreme Court. What the Supreme Court will do, I don't have a clue. It's an interest, given that we have a very conservative Supreme Court. Who knows? But there is a big difference in the underlying legislation. And the real question is failure to warn. The more the cases come out showing Roundup is not dangerous, and hopefully the lawyers will stick it in as a footnote, and by the way, Roundup isn't dangerous, I think the stronger their argument will be, because then the Supreme Court will say, and by the way, this stuff isn't dangerous to begin with. Okay, there's one, oh yes, I want to end on fake food and real water. I'll end on here on the forever chemical. So I wrote about this about 2 or 3 years ago. There's a company called Real Water, and they were marketing real water. Problem was the real water was marketed as an alkaline water, meaning it was a basic water like bicarbonate, like put bicarbonate of soda in your water and you'll have an alkaline water. They said this stuff is really healthy for you, and they're marketing it as really helpful. And 15 people got really sick, one including one needing a liver transplant, and a bunch of children got really, really sick. And they recalled it. They had no idea how this was caused. That's the advertisement has slightly negative ions, meaning it promotes a balanced pH. That's not true. If it's alkaline, it's not balanced, and can detoxify. I don't know what they're detoxifying. Anyway, the FDA does an investigation. Everybody's contaminating. They recall the product. And 2 weeks ago, $3 billion in damages was awarded against Real Water. Turns out in their process of, and they said it was a contaminant, in their process of alkalizing the water, they subjected it to some kind of electrolysis, and they added hydrazine, which is jet fuel, to it. Now, this is not good stuff. And their defense was, we tested it in accordance with the industry standards, and industry standards doesn't require us to test for jet fuel. Industry standards is not meant to test water that's been subjected to an unusual manipulation. So that's the issue on Real Water. You can still, even though it's recalled, you can still get it. It's sold online, and it was, at least when I last checked, this may not be gone, it was available in some stores around the way. And so here's an example of a really bad product taking advantage of the wellness addicts in the population. Okay, so here's PF. This is the forever fighter chemical. I'm just going to end with that because it's Whether or not this chemical is a forever chemical, I have no clue. The settlement is about, there's a settlement in the works on water exposure. They polluted water. It's used in firefighting. So they mix the chemical with a foaming agent, and it's called aqueous film forming foam. So it's called aqueous film, AFF. And they're saying it's not dangerous. And here is my fear. There are a lot of people saying this stuff isn't dangerous. In 2015, the chemical was known as C8. It's made by DuPont. It was made by DuPont, and it's used in Teflon. And in the toxicology industry, it was known that there were some dangers associated with Teflon. Wasn't sure exactly what. A lawsuit was brought, which was resolved in about 2015. And it had a very interesting way, which was resolved. Both parties, DuPont and the plaintiffs, agreed to have an independent court-appointed epidemiological study to testify about 5 or 6 cancers that were claimed by people who lived in the water seepage area around DuPont. These people were heavily, heavily exposed, and as we know, dose makes the poison. And the epidemiology study took 7 years because every time one side didn't like it, they had to redo it. And at the end of the 7 years, this study, which withstood both plaintiff and defendants' objections, found that at least in some doses, the chemical does cause 6 cancers. And so it's not a well-known study. I only know about it because it was part of my dissertation, which I started in 2015, and I was looking for a certain kind of case. It's not well reported. It only pertained to that case. It's not a reported case, but it's there, and the evidence is there. And when negotiating the cases, this is something that corporate DuPont should be aware of. I will tell you, at the time, there was a commentary that said, how could DuPont do this? They obviously knew, apparently in their corporate records, they knew that the stuff was hazardous. I don't know, I'm just repeating what somebody said. And was this another example of the MER 29 cases where they just sequestered money and hope it wouldn't find the light of day? And here we are fighting the light of day. And on that, thank you for listening, and I'd be pleased to take questions.
Anyone have any questions?
I have a question. Using the example of the breast implant cases, since I can recall that, yes, it was put aside by the Institute of Medicine study in '98, but I think about 3 years before that, there was a pivotal case where a federal judge in Oregon, and I'm forgetting his name, did something that was unusual, and that was that he appointed his own scientific panel of experts rather than accept the experts from either side, and remarkably picked 3 very qualified people. And the outcome of that case was that the experts from the plaintiff's side were declared junk experts and were never able to effectively testify again. So my question is this: since that time, has it become more common for judges to appoint their own panel, and does that do any good? Because perhaps judges would not appoint a qualified panel.
That option is available to the judges. Generally speaking, for whatever reason, it's the parties that object to it. In this case in Australia, this Judge Lee case, he begged the parties to let them pick, and neither side, neither Monsanto's lawyers nor the plaintiffs wanted it. For one reason is they can't cross-examine the expert, so they don't know which way they're going. What the judge in that case did was he appointed one expert not to persuade him, but to interpret if he didn't understand something. Mm-hmm. And that seemed to have worked well. In terms of picking court-appointed experts, my colleague Joe Cecil wrote a case, it was a medical malpractice case, and the judge appointed a panel of 3 people from 3 different specialties, and they all came back with 3 different resolutions.
Yeah.
So, and that's part of the problem, is that a lot of this stuff isn't cut and dry.
Mhm.
The vehicle is there. Generally, the parties don't like it because they don't have control over it.
I see.
So, Barbara, going back to the Zantac litigation, I mean, I read some of the articles you wrote and dug into it a little bit, and there was an interesting piece where, and I can't remember if it was what you wrote or what somebody else wrote, but it says a drug is adulterated if it consists in whole or in part of any filthy, putrid, or decomposed substance. And, decomposed substance, anytime you have a drug, there's going to be some decomposed substance, i.e. the drug will decompose. At some level, could be minuscule. And so it sort of struck me that this was an impossible standard to meet, number one. And secondly, one of the things that happened, you said Zantac came on the market about 1980. That was sort of somewhere around the time that I got into the pharma business. And, the analytical technology was way worse back then. And, if you could find, 0.1% of an impurity, you probably couldn't do much better than that. It had to be at that level for you to get it to come up on a chromatogram or something. Now, of course, we can find, parts per billion, and so the idea that now you can find NDMA in this Zantac drug, was it there all along? I suspect so. Right?
The FDA standards is you're allowed if it's 96 nanograms. What Valisure did was it heated it up so they got 30,000 nanograms.
Yeah.
Something like that. They contorted it and did things. One of their things was they put it in a car in Texas and it reached whatever, and they said, and that means Texas is on the same latitude as Georgia. That means that the heat in Georgia would be the same way, but more humid. It's like, hello? So, I mean, it was like, I couldn't believe that they wrote this. The piece about the degraded, that was written I don't know when exactly it was written, a long time ago, when you're talking about seriously degraded drugs that you could pretty much see. Now, I will say why most drugs are not, well, they do say keep in a cool, dry place. They are, keep in a cool, some drugs even say keep refrigerated. So you have 2 questions. At what point does a drug become degraded? And that's probably not clarified precisely and probably should be clarified. And it's kind of like things, you know it when you see it. There was a case where a movie star had a natural Tylenol and it degraded and it caused harm. And I wrote a piece saying naturally it degraded. It doesn't have any preservatives in it. Of course it's going to degrade. But she was marketing, oh, it's preservative free. Well, you get what you pay for. If it's preservative free, it's going to degrade. So eventually they took, after it caused harm, they took it off the market. So, and most drugs have expiration dates on them, and they do test them over time to see that they maintain their shelf life up until the cutoff. And as far as I know, those cutoff dates are shorter than the drug could work. And in many cases, the cutoff dates are not due to degradation, it's due to lack of effectiveness. It loses its effect. It's not that it becomes dangerous at that date, it just might not work after that date. So there are dates. That quote comes from a Ketam case, comes from the language that supposedly enables whistleblower suits, there was a recent case where the judge said private parties shouldn't be allowed to bring them, not having to do with this. And I suspect that those cases will fall by the wayside as time goes on.
Getting back to degradation, pictures you showed indicated a discoloration. Were people just ignoring that? Where is that? How does that fit in?
Those degradation under these absurd extreme conditions. Now, having said that, there was an allegation that the drug was originally white or blue, and they changed the color to make it peach colored to cover the degradation. The really ugly stuff is manipulated drugs. These are not drugs that you have in your cabinet, and if you did have your cabinet, you would throw them out. I mean, it wouldn't even be
exactly.
So these are manipulated drugs, and as I said, this whistleblower case is not designed to prove the product is dangerous. Their claim is that GSK defrauded the government by saying it was a good product, when in theory, 400 times over in theory, it could degrade. And rather than dealing with it, I mean, these are just allegations. They're just thrown out. They have no legal weight whatsoever. But rather than dealing with it, GSK just settled 80,000 cases. Mm-hmm. And that's what bothered me. These are plain and simple allegations by a company that we know stoops to the most outrageous manipulation in the world. We know this.
They don't even sell Zantac anymore, do they?
No, you cannot get Zantac, you know, other things, cannot sell Zantac. I will tell you that the process by which Zantac degrades is supposed to occur in valsartan, which is available on the market. There were some lots recalled, but if anyone takes valsartan, you might want to keep it in a cool, dry place.
I take valsartan.
Well, I told my husband to put his in a cold, dry place too.
Right. Don't leave it in a car in Texas.
Don't leave it in a car in Texas. But this is stuff that, I mean, I keep some of my medication in the refrigerator if I can.
Let's not forget that our own Josh Bloom has written about the longevity of medications. And if I'm remembering correctly, he said if they're in tablet form, they're going to last a very long time, but beware of capsular medications, and also don't expect your antibiotics to last very long as far as effectiveness goes.
Correct.
That's right. But the point is that the concern is not that they'll be dangerous so much, but they won't be effective after a certain date. Now, having said that, if it has an expiration date and it does become dangerous, the manufacturers can step on it. But the real concern is effectiveness, not danger. And those really ugly pills that are discolored, they didn't test them to say that they have NDMA. They just look disgusting. You know, they're not marketing lipstick. How beautiful it looks, but these are contorted conditions. So, as I said, they're meaningless from a legal standpoint. The only significance is shortly thereafter, $2 billion were spent in settlement, and that bothered me. I just personally.
It just encourages the bad behavior to continue, right?
Especially when they're on the verge of having a hearing on the applicability of evidence that one judge has already found faulty. In other words, the Delaware Circuit is now going to look at the same evidence that Robin Rosenzweig wrote a 346-page decision. And she went through every single one of it. They're going to have a hard time saying, this is a jury question, and they may say one or two of them are jury questions, but they're in a good. Now, as I said, the Delaware case doesn't apply to them, and I guess they don't have any responsibility to care about what we care about is the whole global climate or the products of their competitors. But that's where it is.
Okay. Barbara, your graph that showed the sudden increase of complaints at the point that the drug was announced withdrawn made me wonder, has anybody ever studied what the impact of the listing of all or most side effects on TV pharmaceutical ads has had on litigation? And I guess that's pertinent to today's politics because I believe that one of RFK Jr.'s ideas is to remove pharmaceutical ads from the TV, which I find appealing. I'd like to see choices go back to something between the doctor and the patient, but maybe I'm just old-fashioned.
Well, Jack, I think that's also what happens in every other country in the world, isn't it?
Yes.
Can they go back to having the lawyer ads taken off TV too?
Oh, that would be good.
We don't have a TV. I don't even know what's on television.
No.
I don't want to be polluted by that stuff. So
You're
we
not
don't
missing
watch-
much.
Well, and
We
you're
don't watch-
missing all the side effects, Barbara.
Yeah.
but it's on all the labels, it's on all the inserts and the product inserts you get. And those labels, they're required to list every single
Yeah.
side effects, whether it's related or not, if it's in temporal proximity. So they list them.
I'm remembering Henry wrote something about a study where listing them made no difference whatsoever to the sale of the drug.
Well, I know that my PPI used to have this piece of paper glued to the top of the bottle when I picked it up at the pharmacy, and that piece of paper folded over was thicker than the bottle itself. Now that's not there anymore.
Mm.
It's not there anymore.
Not there anymore.
I think
All those side effects have gone away.
I guess.
online, they'll give you a I don't know, one of these square things, and you take a picture of that, and boom, it'll take you to the website, and there you have all that information. Useless though it may be, recognize, of course, we all do, that all chemicals are bad.
Yes.
Well, all chemicals are, that reminds me when I was getting physical therapy and the woman next to me is on the table is telling the physical therapist, and physical therapists know a lot of medicine, that she just started taking some special natural salts. I said, what's so special about a natural salt? She goes, it's natural. I said, all salts are natural. She goes, no, these have no chemicals in it. I said, everything has chemicals in it. Water has chemical. Water is made of chemicals. She goes, no, it's not.
I think Josh is also opined on that aspect of it.
I always like the 200,000-year-old Himalayan salt bottle that has an expiration date on it.
Oh, really? They've got an expiration date on those.
Around 200,000 years, but it expires in 3 years.
And I suppose that brings the point is that we've got to educate kids in school, high school students, because these are the populations that will take advantage of this real alkaline water.
Yeah.
I mean, the consumers who bought alkaline water, besides spending extra money on it, are dupes because they believe that salts, natural salts for which you pay double, triple, don't have chemicals in it. In water, you could get alkaline water. So where does that education start? It's got to start in the schools.
Yeah.
I mean, we're lucky if they can balance the checkbook when they come out of high school these days. So,
well, we know that 84%.
It's a lot of challenges. Sorry,
84% of them cannot read a ruler. That's bad.
Yeah.
I'm sorry, but anyway.
Read
a ruler. They don't know how to read a ruler. They don't know what all those little dashes are for.
Fractions of the inch.
Yeah. So, anybody have anything else?
Yeah. So, Barbara, you mentioned briefly the one at the bottom of your list about Gilead. I used to work there. In fact, I've worked on that case. So this is the one where they invented a new prodrug of an old molecule, and it turned out eventually to be safer, but they didn't know it at the time, and so they actually stopped its development because the original drug looked quite reasonable in terms of its safety profile. And they're now being sort of pilloried for the concept that they should have known that it was better. And the idea being that if you ever develop something better, you should have done it sooner.
Well, I remember one of my professors in law school saying, do we want a perfectly safe society?
Mm-hmm.
And initially, that sounds wonderful. And when you start getting into perfectly safe, and when I taught the same subject, I remember some of my students eventually saying, well, if it's perfectly safe, then there's no progress. And another one says, perfectly safe, everybody has to watch you all the time, because what if you do something unsafe? And there are dangers of being perfectly safe. The question, and even the drug that they marketed, as I understand it, is safer in a certain population than the newer drug that's marketed as, quote, safer. There are indications for the later drug, which is claimed to be unsafe. In certain populations, that drug is actually better. So the question is that somebody sets a bright line as to when something is safe. And that's the FDA for the time being. If you want to change it, by all means.
Well, as you know, their concept is the safety and efficacy are basically sort of looked at together. So you're looking at the sort of therapeutic index within the population, defined by the patients at risk. And so you never have absolute safety. You only have safety relative to the benefit, right?
Right. You cannot have absolute. There is no such a thing as absolute safety. Otherwise, we live in a bubble and nothing would happen. So the concept of absolute safety doesn't exist. The question is,
we as a I'll call it scientist, use that term. Things are safe, things are not safe. But safe is, as you're pointing out, a relative term. Are we not doing a disservice to society by not pointing that out in our conversation? No, this is safer. It's not safe, it's safer.
And actually, the Gilead situation, it's safer only for a small, or for a particular portion of the population. It's not even safer across the board. It's not, number one. Number two, at what point, as I recall, it was in the middle of a phase 1 or a phase 2, at what point along the continuum of drug development do you get that information? So being that if you're a drug company and presumably you have several things on the stove at the same time, when I cook, there are several pots there, I'm getting, this is a moving target. If I have one drug that's effective and meets the benefit, the basic rubric of, is it safe enough? Do I have to stop it? And if I do have to stop it, that means that that drug that is effective cannot be marketed to people who need it until another two or 3 years go by while I work on this other drug. And you say, well, should have kept working on it at the same time. Well, I guess that's a dictatorship. I mean, since when does a government tell a company how quickly? I mean,
there are give you the money.
There are two issues here. One is the legal issue. The legal issue is, does it fit under one of two rubrics? Is it a defective product? Defective means defective and not unreasonably dangerous. Or another is, does the risks outweigh the utilities? And certainly the drug that was marketed is not a defective product. Then you have the rubric of negligence. And the rubric of negligence is, what would an ordinarily prudent businessman do under the circumstances? So we know the answer to that. Another way to measure negligence is the burden of fixing it. Does the burden outweigh the probability and magnitude of harm? Well, The it is waiting for a couple of years until you have the perfect drug. I mean, it's absurd from a legal point of view. It is so any way you approach it. Then, of course, you have the business aspect and somebody wanting, and this is not my avenue of expertise, but I'm just saying what they want to go in and tell a company how to stage their products. I don't get that. But just from a legal point of view, what are they saying here? It doesn't even, it undoes the whole fabric of law. I mean, the law has precepts and upon which we make insurance decisions, we make legal decisions, we make marketing decisions, we make production decisions. And to somebody say, okay, we want a safer drug. Well, we always want a safer drug. I mean, it's just absurd. So, but I've got to formulate it because I'm so incensed by that.
No, I feel the same way. So I'm looking forward to see how they rule out on this.
Okay, we are kind of running out of time now.
Yep. Thank you.
That's an hour and a half.
I have a
Thank you,
question
everybody.
for,
Thank you, Barbara. And our next meeting will be sometime after the first of the year.
All right.
Thanks.
Thanks, everyone.
Enjoy everything. Take care.